believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft.
From the very start, this man confidently walks into court speaking in a language only sovereign citizens seem to understand, a bizarre mix of pseudo-legal babble and delusional grandeur. Calling himself the executor and sole beneficiary of the trust and estate of the legal persona of Kevin Dwayne Craft, he's already deep in fantasy land. The judges are patient, but the level of absurdity is staggering. It's like watching someone try to use Monopoly rules in a real courtroom. The moment he distinguishes between himself and his legal persona, you know this is going to be a long, painful ride of self-inflicted embarrassment. He believes he's discovered secret legal loopholes hidden from ordinary mortals. But what he's really done is guaranteed that no one will take his argument seriously.
To call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for the summary judgment, please.
You've asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments, the judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking.
He claims to appear under special divine appearance, as if the heavens themselves summoned him for this nonsense. This phrase alone tells you he's not there to argue law, but to perform a ritual of pseudo-spiritual sovereignty. The judge, maintaining remarkable composure, explains how the appellate process actually works: structured, formal, and not a free-for-all debate. Yet, instead of listening, he demands a constitutional court of record, like he's about to unveil a secret scroll. It's tragic and comical at the same time. He mistakes formality for conspiracy and legal terms for mystical power words. The courtroom isn't a temple, and divine appearances hold no legal weight. But that never stops a true sovereign believer from invoking them.
I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kennar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves.
Then comes his favorite sovereign trick: questioning jurisdiction. This man literally brought the case to the Michigan Court of Appeals. He appealed, and yet he stands there asking whether the court has jurisdiction. It's the classic move of someone who has no legal argument but wants to sound profound. The judge calmly clarifies that the court operates under the Michigan Constitution of 1963. But he's not satisfied with real answers. He wants the judge to validate his fantasy of common law or admiralty law. His misunderstanding of jurisdiction is like confusing a car manual with the Bible. Both have words, but one doesn't apply to salvation. He's not seeking justice. He's trying to outtalk authority using nonsense.
Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent or any contract with the state or Title 4D agency to give away mine.
Now, he starts complaining that the trial court ignored his motions and affidavits citing federal rule 55 in a case called Haynes versus Kerner. He believes these filings automatically force the court into default judgment, as if silence equals surrender. What he doesn't grasp is that courts don't operate like customer service. Filing nonsense doesn't guarantee a response. The judge isn't ignoring him. The filings simply have no legal merit. His invocation of Haynes versus Kerner is especially funny, as that case is about prisoners' civil rights, not deadbeat dads dodging DNA tests. But to him, every case he finds on Google is divine authority proving he's right. It's pseudo-intellectual cosplay in a real court.
It's relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context, these are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, with this a constitutional court. The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted.
He then tries to turn the requirement for a paternity test into a Fourth Amendment violation, as if the state is illegally raiding his DNA. It's a desperate leap. Paternity tests are standard legal procedures backed by statutory law, not covert government surveillance. He invokes Monell versus Department of Social Services, but that case is about municipal liability, not baby daddies dodging genetic tests. The mental gymnastics here are Olympic level, twisting constitutional rights into a personal shield against responsibility. He's not fighting for liberty. He's fighting to avoid fatherhood. His paranoia over genetic material exposes the absurd core of the sovereign mindset. Every legal obligation feels like an existential conspiracy.
That's some questions that raise, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test, and if I wasn't excluded, that I would be responsible for that cost. And with that being said,
here the comedy reaches new heights. He argues that the DNA lab and even the state of Michigan are for-profit corporations because they have DUNS numbers. He believes this proves they're private companies forcing him into unwanted contracts. To him, everything with a tax ID is secretly McDonald's and the judge is the cashier. He even compares child support enforcement to being forced to buy a Big Mac. McDonald's can't force me to eat their burgers. It's the perfect metaphor for his thinking. Oversimplified, absurd, and completely detached from how government works. Courts don't need your consent to enforce law any more than gravity needs permission to pull you down.
Fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority.
He insists that the state forced him into a contract by ordering a paternity test, arguing he never consented to do business with them. This is a core sovereign delusion. The idea that all government actions are commercial transactions that require personal consent. He treats legal obligation like a gym membership he can cancel at will. The problem is parenthood isn't a contract. It's a biological and legal fact. His endless talk of no contract, no consent only proves he's trying to convert his moral duty into a corporate debate. His worldview replaces accountability with paperwork, and it's both cowardly and pathetic.
Must provide proper documentation such as a promissory note contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses.
Make his argument seem factual. He proudly lists out Dune's numbers for Kent County, the Friend of the Court, and the state of Michigan. He genuinely believes this proves they're all private businesses profiting off his misery. What he doesn't realize is that Dunn's numbers are standard identifiers for entities that receive funding, not proof of privatization. It's like claiming hospitals are fake because they have tax IDs. His speech shows how deep online misinformation can rot the brain. He's quoting data he doesn't understand, reciting it like scripture, thinking numbers equal proof. It's pseudo-research disguised as rebellion.
It's a human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them for, it incentivizes.
Then claims the state profits from child support through incentive payments, turning legal enforcement into a sinister business scheme. He believes the government makes money off broken families, not realizing those funds ensure children actually get fed. The irony is rich. He's complaining about a system designed to make sure his own children aren't neglected. His warped sense of victimhood transforms parental responsibility into oppression. Instead of admitting he owes child support, he accuses everyone of profiteering. It's a moral inversion. the guilty playing victim while children go without support.
You know, it seems like they entered me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22, and it's basically it's evidence. They didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of
yes.
time. We understand that you raise issues of disclosure,
Yes.
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I will ask you to dismiss.
In his closing moments, he loops back to his greatest hits. No contract, no jurisdiction, no injured party, no consent. It's a tired script every sovereign citizen recites when they run out of ideas. The judge finally cuts him off, mercifully ending the rant before it spirals further into fantasy. What's striking is his total refusal to accept that real law doesn't bend to his self-invented rules. His defiance isn't courage. It's ignorance parading as enlightenment. In the end, the only thing he's proven is how deep the sovereign rabbit hole goes, where personal responsibility dies and